Hi, I'm Candice Munini-Govender. Welcome to Coffee with CNG. This is the Law Unplugged. I'm here today with my colleagues Cassandra Holcroft and Pravashni Govender. And today we'll be exploring unopposed divorce and mediation. We're going to be talking about what is an unopposed divorce and why do we need to choose mediation when it comes to unopposed divorce. So, ladies, welcome.
Thank you.
Thank you.
Thank you for joining us today. So, Cassandra, can you tell us what is mediation?
So, Candice, mediation is basically a conversation. And it's a conversation that is facilitated by a neutral third party. That third party must be unknown to both parties. Never before have they met. So that there's no conflict of interest. It is a process that basically is voluntary, and that's very important. It's an important principle of mediation, is that during the process, the parties are there at their own volition. In other words, completely voluntary for them. And at the same time that it's voluntary for them, it's also voluntary for the mediator.
Okay.
So that's worth mentioning.
Yeah.
It's a confidential process. And by that we mean whatever is mentioned within that safe space of the conversation stays within those walls. It is without prejudice. In other words, the information that is discussed by the parties, facilitated by the mediator, will only ever, it is without prejudice, which means that the information can never be used by either of the parties in a court of law.
That's interesting.
And that information is only binding on the parties once it has been reduced to a settlement agreement and signed by both parties.
Okay, so when is an ideal time for a couple to consider mediation in their divorce?
So the ideal time would be once they've come to the decision that they no longer want to live together, either as partners or as man and wife, and they want to go their separate ways. They basically have agreed on this, all right? And before they then issue summons, which then initiates the divorce process. So once that agreement is made that they no longer want to live together, they then will consult a mediator, and the mediator will help them have the conversation. And only once that settlement agreement is reached, then they go and they contact an attorney who will then initiate the divorce process.
Okay.
Having said that, however, even if the divorce process has been initiated by virtue of a summons, the parties can opt to still mediate.
Okay.
So it doesn't mean that if you haven't mediated from the beginning, you can't mediate. You can mediate at any stage before judgment is made.
And I know now also mediation has become a mandatory step, before we issue a summons. Can you tell us a little bit more about that?
Yes, certainly. So the reason behind this is that many people actually go through the whole litigation process for something or for a matter that could have been agreed upon by the parties to start off with. And the courts have incorporated what we call a Rule 41A, and that is that parties have to mediate. Okay, now I'm going to go back to the whole voluntary aspect of mediation. So remember, mediation is voluntary, but the parties have to go to mediation, but they don't have to settle. Okay. So just because it's mandatory, it doesn't contradict the whole voluntary aspect.
Sure.
It is still voluntary, and the voluntariness comes in when it comes to actually making a settlement agreement.
Okay.
So in terms, just to go back to the Rule 41A, in terms of this rule, the parties they have to undergo some sort of mediation. They have to agree to meet with a mediator.
Yeah.
And there has been some case law in which parties that have not mediated, in other words, they've said they're not interested in mediation.
Yeah.
And the judge looks at the matter and says, you know what, this could have been mediated. I don't believe that there needed to have been the litigation that has happened.
Yeah.
And there can be a cost order against the party who didn't agree to mediation to begin with.
Yeah, I hear you. So, like, just out of curiosity, so we do the Rule 41A, but it doesn't mean that mediation has to be successful.
No,
correct.
it doesn't.
But even though it's mandatory, it's not something that has to be successful as long as it's been attempted or has been a failure of it.
And I think it's also to try and stop the clogging of our courtrooms. Mediation often saves the party time. And costs as well, because a long drawn out litigation process is going to take you nothing less than 2 to 3 years at minimum, if not more.
Yeah, you're still right. Sometimes we take these matters on litigation and it runs for 2 to 3 years and we just end up settling at the end. We waste a whole lot of legal costs just to settle at the end.
And you're right, Varsha, you're absolutely right, because so many of the matters are settled on the morning of the steps of the court.
Yes.
Whereas, and now there's been costs involved, there's been time involved, there's been emotional energy that's been expended, whereas it could have just been settled in the process, because at the end of the day, the mediation process, as I've said to you, is a conversation. Okay.
Yeah.
And it's a third party, the mediator, facilitating a conversation between two people that left in a room on their own can't have the conversation.
Yes.
Yeah.
But the mediator then mediates the discussion between them. And that's why it's very, very, very effective.
I think also it's important to note that the mediator is a facilitator.
Yeah.
The mediator is not there to tell the parties what to do or what to decide. The mediator is there to ask the probing questions so that the parties themselves can come to the conclusion. So, Cassandra, in your experience, how many sessions of mediation does it take for a couple to come to resolution?
So obviously, Candace, each matter is individual and some will take more than others. But ideally, when it comes to family mediation, the sessions are between 1.5 to 2 hours. All right. And it might take to discuss, depending on, how many issues there are to be discussed. It could take maybe 3 to 4 2-hour sessions.
Okay.
Yeah. So probably a total of about 8 hours. 8 to 10 hours would be the maximum it should take. Anything longer than that, and then I don't believe that progress is being made.
Okay. And does it happen all together at once? How is the hours split up?
No. So basically, they are split up. In family mediation, where there are a lot of emotions involved, people become hit up, people are emotional, and unfortunately it does affect their decision-making skills when emotions are involved. Yeah. So unlike civil mediation, which you can do over the period of 8 hours, here, where emotions involved, we split up those 2 hours. Okay. So it can be 2 hours, say, on a Monday, perhaps 2 hours on the Friday, or it can be 2 hours on the Monday and 2 hours the following Monday. Because it also gives parties time to sort of go away and think. Very often there's homework to be done. Yeah. There's documents that there's information that's got to be gathered with regard to, say, for example, assets, finances, income and expenses, etc. So for that reason, it can't all be done in one day.
Okay. So what are some of the qualities that a couple need to look for in a mediator?
That's a very good question. So basically somebody with experience, in the process of mediation. And the other very important quality is that they've got to be a NABFAM. And NABFAM stands for the National Accreditation Board for Family Mediators. So that mediator has to be accredited with a NABFAM organization. For example, one of them that I'm a member of is called the South African Association of Mediators, SAM. The others is called Social Justice. But it's very important that before requesting the assistance of somebody who is a mediator, that you have a look to see that they are NABFAM accredited. You obviously also need somebody who is going to remain impartial, somebody who's going to treat the parties as equally as humanly possible. And somebody who can, remain neutral, as I've just said, and somebody who listens,
Definitely.
Yeah.
So it goes without saying that a mediator has to be somebody that both parties don't know.
Exactly.
At all.
100%. Absolutely. No, otherwise there's a conflict of interest. Yeah. Yeah.
Okay.
So that being said, can legal representatives be present at a mediation?
Yes, they certainly can be, as long as both parties are represented legally. All right. Otherwise, we say there's a power imbalance.
Sure.
Right. Which mediation is, complete opposite of any power imbalance. So, they can if they are both legally represented. However, first prize is just to have the parties in the room. There is huge value in the legal representatives in that they can then, the parties, once they've discussed options, they can then either after each mediation session go and just bounce ideas off, get legal assistance from their legal representatives, or right at the end, once that settlement agreement has been drafted, the legal representatives can obviously peruse the settlement agreement just to see that no party is being prejudiced.
Okay. So what happens if one party is not willing to participate in the mediation?
Yeah. So unfortunately, it is very important that both parties are present, because it is voluntary. And so if one party is not prepared to participate, they cannot be forced to.
Yeah.
And then the parties will be forced to go the litigation route. However, what I did say earlier about the Rule 41A is that if a party does refuse to participate in mediation, the mediation certificate or mediation notice that is signed will state that party X did not or refused to participate in mediation. And as I said to you, there is case law to the effect that they've had cost orders against them.
Sure. So what is the process if a couple had to come to you for mediation? What are the next steps that will happen?
All right. So invariably what happens is I hear from either the husband or the wife or party A, party B, who makes contact with me. And what I then do is I say, obviously, please could you, this is my email address, please email me, because right from the start, I've got to be impartial. I can't be seeing to communicating with one and not the other. So I will say, does obviously your spouse, your partner, are they open to mediation? Yes, they are. Please send me an email. And in that email, you say you request my services. I then respond. What I do is I send you just some information about what mediation is. I'll tell you what the costs involved are. And I also send something called an agreement to mediate. All right. Which basically states what the principles of mediation are. And you then have an opportunity to read through that. We then schedule a time to meet that is convenient to both parties. And at that meeting, I will then go through, if you've got any questions about the agreement to mediate, we can discuss that. And we then sign the agreement to mediate. I explain to you again what the process of mediation is. And we also discuss various ground rules. And you can imagine those are important. No raising of voices, no calling each other names, calling each other by your first name. Sure. Listening, with the intention of hearing rather than replying. Those are basically some of the ground rules. And I get people to sign the ground rules. Because they've got to take ownership of them.
Yes.
And then once that is done, each party is given an opportunity to make what's called an opening statement. All right. And they basically, the opening statement involves, why are you here? What is it that you're hoping to achieve today, or achieve during the mediation process? So once that happens, if each party gets an equal opportunity, and then what we do is, as the mediator, you ask the probing questions and you set an agenda with what the issues are that need to be discussed.
So what are some of the key issues that are discussed in mediation?
So things like very often contact and care of children, if they are minor children, and that then leads to the drafting of what we call a parenting plan, all right, which is very important for going forward in the relationship with children. Division of assets. All right. So if parties are married in community of property, we would then just, they would come with all their assets, liabilities, and we would then discuss the splitting of those assets and liabilities. If married, with an antenuptial contract, without accrual, then obviously we would look at who owns what and go into a discussion about that. With accrual, we would then have to do the accrual calculation.
Okay.
Right. Things like pension interests, those are also issues that are discussed. Perhaps if there's a need for spousal maintenance, all right. There are various types of spousal maintenance, but that is an option that can be discussed.
Yeah.
And anything, that the parties, I mean, I've even had mediations where we've discussed the contact and care of pets. So that is so very important.
Because pets are part of the family these days.
Absolutely.
So, and they belong to the party, so they can be agreed to.
And they have relationships with the parties, and these are real aspects,
Yes.
It's
practical.
It is practical.
Yeah.
And, the other advantage of mediation that perhaps I should have mentioned earlier was the parties themselves are empowered to make the decisions.
Yes.
You haven't got a judge or a magistrate that makes the decision for you. So especially when it comes to caring for the children.
Yes.
Nobody knows their families better than the parents.
Exactly.
And the same with the animals.
Yes.
I mean, if you had to put before a judge who the dog or the cat's got to go to, I mean, it's not going to be the same as when you've got parties agreeing to it themselves.
Yeah. And also looking at it practically, I mean, when it comes to the pets or the children, from a practical perspective, how is our work schedules going to pan out practically with the picking and dropping up of the kids from extramurals, from school? And, it's that practical aspects that you want to have a hand at decision making with, and not leave it up to a third party who's a judge.
Absolutely.
To make that call.
Yeah. So there's no cookie cutter approach.
Yes.
Everyone is individual and treated individually.
Definitely. So after the parties have come to an agreement, what then happens?
Okay. So remember I said to you, and I'm going to reinforce this again.
Yes.
Mediation is without prejudice.
Yes.
In other words, any discussions that are had between the parties. Often you find, for example, somebody will suggest something and then they'll talk about it and maybe reach agreement, and then they'll come back to the next session and they'll think, no, actually, you know what? I'm actually not happy about that. That is what we call confidential. That is what we call without prejudice.
Yes.
In other words, the other party can't then go to their lawyer, or they can't go to the court and say, oh, but in mediation, this person suggested this. All right. So that is what the without prejudice means. Nothing can be used in a court of law unless it has been reduced to writing in a settlement agreement and signed by both parties. Yes. So mediation goes well. Parties are happy. They manage to agree. The mediator will draft a mediation agreement, a settlement agreement, and the settlement agreement will then be signed by the mediator, by both parties. And once this has been done, then the parties will take the agreement to an attorney who will then carry out the unopposed divorce or assist them with the process of the unopposed divorce.
Okay. And what would you say are some of the advantages of mediation?
So definitely costs involved.
Yeah.
I think we all know that the cost of litigating a divorce, and especially an opposed divorce.
Yeah. And another thing that I actually didn't touch on earlier was who pays the cost of mediation?
Yes, that's a very good question. Yeah. Thank you for that, Candace. So basically, the parties should pay. It's actually up to them to decide. Yeah. Again, it's a decision that's within their hands. So they can either opt to pay 50-50, or what they can do is they can, the one party pays for all the costs. It's entirely dependent on how they're going to structure it.
Their financial circumstances. Oh, thanks, Cassandra, for that. Then moving on to the next part of things, which is the unopposed divorce. Vash, can you please explain to us, once an agreement is reached in mediation, what happens next?
So once we have the agreement done, legwork is done by the mediator, we have this amazing agreement, parties are all in consensus, that means it's now opposed. We can now proceed with what we call a summons. A summons basically sets out the divorce terms and conditions. And that really starts off the process on an unopposed divorce. And then we go through the process of actually going through serving summons and getting a date and so forth. And the legwork really is done at mediation. Once you have that agreement done, unopposed divorce, straight to summons.
Okay. And what role does the Family Advocate's Office, play when it comes to mediation and unopposed divorce?
The family advocate plays a very important role in divorces, be it unopposed or opposed. The family advocate has to be satisfied that the agreement that has been concluded is in the best interest of the minor child. Once a family advocate is satisfied that this is the best interest of the minor child, we can proceed with the divorce. If the family advocate is not satisfied that this is the best interest of the minor child, we go back to the drawing board and we do an inquiry.
So what are the essential documents that are required for an unopposed divorce?
The essential documents would be the mediation agreement, being the settlement agreement, the parenting plan, your marriage certificate, your identity documents, your antenuptial contract if you are married out of community of property. And those are the basic documents needed to proceed with the divorce.
Okay. What is the typical timeline that it's now taking, at court to get divorced?
So the timelines vary depending on the courts that we proceed with. The justice system varies in the courts that you go to. In the high court, which we highly recommend, it's very easy, it's quick, 3 months maximum. When we go to the regional court, that's where we really see the justice system taking place, and that can go from 1 to 2 years just for an unopposed divorce. It is a lengthy period in the regional court.
Yeah, because I know, look at our offices, we do prefer to use the high court. It is a bit more efficient, and you may pay a little bit more in terms of for the high court, but you're getting, more timeous results.
Yeah, you get it.
If you've agreed already in terms of your settlement agreement with mediation, you don't want to wait for your unopposed divorce to be finalized in like another year, with the lower court. I think also what's very important is that some people still think like, unopposed divorce happens like in the movies,
It does.
as soon as you sign your agreement, then you divorce. But that's not the case in South Africa.
Yeah.
So I think what we need to highlight is that in mediation is that you come to a settlement agreement, but you still have to go through the process of an unopposed divorce and summons being issued in order for you to actually have a divorce order granted. It's not instant when you sign the settlement.
Yes. I'm glad you said that people think that once you sign the settlement agreement that you divorce, and people have this misconception that in order for divorce to actually go or be unopposed, you have to sign some kind of document. Once you get served with a summons, there's nothing you sign unless you want to oppose a divorce, and then you do notice to oppose. But it's not like the movies. You issue summons and that is it. Unless you do a settlement agreement, and that to itself is not a divorce.
So what role does the court play in your unopposed divorce?
The court plays a very important role. The court has to be satisfied that this marriage has broken down, that there's no chance of reconciliation. That means that the party instituting the divorce would have to satisfy the court by leading evidence.
And appear
and stand in that daunting little box and answer all the questions about your marriage for the court to be satisfied that that divorce is over. In order for you to get a decree of divorce, unfortunately, be it opposed or unopposed, it is one of the things that has to happen.
Yeah. And basically you are proving to the court that the marriage has irretrievably broken down. And also that your arrangements that you've made in respect of your assets, in respect of your children, and the best interest of the children and all of that.
But also, like, you say you've got to stand in the box and it's daunting. But Vash, you are very good at teaching people, putting them at ease, and advising them what questions are going to be asked. And so, you're very good at putting people at ease and helping people in that process.
Thank you. So, that 5 minutes in the box is not the hardest. It's the 8 hours, 10 hours, and that mediation is the hardest. So people think, I got to go to court. I got to give this evidence. I can't do this. But that's not the worst part. That's the freeing part. It's the mediation. It's coming to an agreement, coming to a consensus so we could get to the end of that process. Yeah.
So, I know, here at CNG, we don't treat our clients as mere robots. We all are humans. We all have emotions. When there's children involved, especially, we don't want to have an unsettled environment for the kids. Divorce in itself is such a big deal for the parties and for the children adjusting. So beyond the aspect of mediation and unopposed divorces being, a cost-effective manner of dealing with things and also, saving us time. What about the emotional and psychological benefits of choosing mediation and unopposed divorce?
That's a very good question.
Yeah.
Once the divorce is done, whilst you're going through the divorce, there's a lot of emotion. Mediation helps people get on the same page because once you divorce, you still have to live. You're still tied to this person. You have a child. And the best thing to be able to do is to be able to co-parent.
Yes. And you have to learn now to transition to
co-parenting. And, that mediation is so integral and important to retain a relationship. Because once you divorce, the relationship doesn't end, especially when you're married. It continues. It continues and you still have to learn. And mediation teaches you that it sets it out for you how to deal with that.
Future relationships.
And that's why we always speak about mediation being also a tool in preserving relationships for future.
That's right.
We're not saying that you're going to be all pal again, with your ex, but there has to be a respectful relationship going forward in order to co-parent and live harmoniously. No one wants to fight forever.
So it's not just procedural. It's important. It really is important,
So, are there any situations you feel where mediation or unopposed divorce may not work or is not advisable?
Where people are not seeing eye to eye, you're changing your mind every day. You're like, okay, I'm on this page and then I'm not on this page. People have to be on the same page for mediation to work or even to go through a divorce. If you're constantly changing the goalpost, that means you're not ready for a divorce. There's too much emotions involved and you're really not ready for that. It has to be a consensus. Mediation has to be consensus between the parties. If there's no consensus, there's no mediation, there's no divorce. We'll be doing an opposed divorce, fighting a long drawn battle for no reason. People have to be on the same page with mediation for it to be unopposed.
Yes. And I think also in some situations, like, if there's, terrible domestic violence, power imbalances, that may not be the correct situation to do a mediation.
No.
It may be a situation where mediation may fail.
Yeah.
You can attempt a mediation, but it could be that it would fail because of the circumstances. And as we've said, every matter differs.
Yeah.
So what advice would you give to a couple who are considering divorce and exploring unopposed divorce and mediation?
Go to mediation. I really suggest going to mediation first. Divorce is not easy. It's one of the most emotional things. And it can also be described as a death. It feels like a death. In order to deal with a death, you need to heal. So mediation is a way of healing and sorting out and ironing out all your issues. Do mediation and then go through your divorce.
Okay.
And also with mediation, people sometimes realize, okay, maybe we just need a plan in place and maybe it may not lead to divorce, So,
you never know.
You never know.
Yeah. So just some scenarios, right? If someone says to you, my spouse and I have already agreed on everything verbally, do we still need mediation or can we go straight to an unopposed divorce?
No. Don't trust that man. No. As attorneys, we believe everything needs to be in writing. We can say one thing tonight, tomorrow morning, we're on the next thing. Everything has to be in writing. I never agree for anything to be done in verbal and then we just do an opposed divorce. It never works. It has to be in writing.
I think that's the best advice, that everything needs to be in writing. What if one party is in a different province or lives out of the country? Can they still proceed with the divorce?
Almost definitely. Our courts allow us to serve in different forms, serve via newspaper, serve via Facebook. It's always possible to get divorced even if you're out of the country.
And that would be an application for
Digital citation. Yes. Yeah. So, yeah. So it's not impossible if my husband is in Zimbabwe and I'm in South Africa and I can't get a divorce. You will be able to get a divorce.
Definitely. And I think it's also important for us to understand jurisdiction. That, it's the court in which you are domiciled that has jurisdiction to hear your matter. So if I live permanently here in Durban, the Durban High Court, for example, will have jurisdiction to hear my matter. Okay. So if your spouse, if you're living in Durban, but your spouse is living in the UK, for example, you can institute your divorce proceedings here. But you will basically have to find an alternate way of serving the summons on him. So you, as Vash gave examples, you can do an digital citation application and request for leave to actually serve by email or Facebook or WhatsApp, or even through a solicitor in the UK, for example. So there are ways around it, and the law does provide for those kinds of scenarios. So ladies, in closing, what would you say is the single most important takeaway you want our listeners to remember about mediation and divorce? Cassandra?
I think the word mediation needs to become the first word that runs off someone's lips whenever there is some sort of conflict. Mediation needs to become a household name, and for the various reasons that we've outlined. I'm passionate about mediation, and I'm passionate about the results that are achieved by mediation between couples that once loved each other and have now fallen out of love, but need to continue with the relationship, be it either because there might be financial constraints or there might be children involved. So make mediation a household name and make that your first port of call when there is a breakdown in a relationship.
And you, Vash?
Mediate before you litigate.
There you go.
I was going to be on your good. Mediate before you litigate. It is so important. It really, really cuts down the process of litigation.
But as you did say, there are certain matters that no matter what happens, you cannot mediate them. It depends, on the personalities involved. And so there will also always be a place for litigation.
We're happy to litigate. Okay.
But certainly, ladies, this has been a very fruitful conversation this afternoon.
Thank you.
I really do believe that alternate dispute resolution mechanisms like mediation need to be explored first before we, seek an order in court. Not only is it saving us time and money, but also helping us deal with the emotions, because we know that also divorce is not just a once-off thing. It's going to also be, how do we live together as co-parents and of children, of pets, etc. going forward. So we also, when we are dealing with our matters here at CNG, we want to see, okay, what is going to be the steps afterwards as well. From a practical perspective, is what the client will bring to going to be in their best interest, in the interest of the children going forward from a practical perspective. And I definitely think exploring these issues through mediation will help the parties in the long term.
Definitely.
I agree.
Thank you, Kate.
Thanks.
Thank you very much for joining us this afternoon on Coffee with CNG. We look forward to sharing more news with you in the future. Should you need any further information, please don't hesitate to contact us on our landline or info@cngattorneys.co.za.